A Supreme Court decision just dropped that most people are getting completely wrong. What I'm about to reveal could save you from federal prison. Hit that subscribe button now. Everyone thinks one case changed both the First and Second Amendment. That's false, and the confusion could cost you everything. The 8-1 decision. Everyone's talking about, but getting wrong. Let me tell you about United States versus Rahimi and why this case matters more than the headlines suggest. The Supreme Court just ruled 8-1 that the federal government can temporarily take away someone's guns if a judge finds they're a credible threat under a domestic violence restraining order. Only Justice Thomas disagreed. That voting split alone should tell you something. This wasn't the partisan battle everyone expected. When 8 justices from across the ideological spectrum agree on a gun case, you need to pay attention to what they actually said, not what social media claims they said. Here's the part that matters to your life. This case involved a man who had violated a protective order multiple times, threatened people with firearms, and was involved in 5 separate shooting incidents while the order was active. The facts were extreme. The court didn't rule on average cases or borderline situations. They ruled on someone who proved he was dangerous through his own actions. But most people online are treating this like the Supreme Court just gave states permission to confiscate guns from anyone with any protective order. That's not what happened. The decision is narrow, fact-specific, and built on procedural requirements that most people don't even know exist. And here's what almost nobody is mentioning. This case also just changed how every gun law in America will be judged going forward. And that part might be even bigger than the restraining order issue itself. What credible threat actually means in legal terms. The phrase credible threat sounds simple until you realize it's doing massive legal work in this decision. Federal law doesn't trigger just because someone files a restraining order against you. It triggers when a court makes specific factual findings after a hearing where you had notice and a chance to defend yourself. According to the statute, the order must explicitly find that you represent a credible threat to the physical safety of an intimate partner or child. That finding is the tripwire that turns gun possession into a federal felony. Most states have different standards for different types of protective orders. Some are emergency orders issued without a hearing. Some are temporary. Some are permanent. The Rahimi decision dealt with orders that included a hearing, notice, and specific threat findings. Emergency ex parte orders, where you don't get to respond first, weren't what the Supreme Court addressed here. Here's a number that should concern you. The Department of Justice estimated that approximately 4.5 million women and 2.5 million men have been victims of intimate partner violence, where a weapon was involved or threatened. Courts issue hundreds of thousands of protective orders annually. Even a small percentage of those orders involving firearms creates tens of thousands of people potentially facing federal prosecution. The problem is that many people under these orders have no idea they're violating federal law by keeping guns in their house, and ignorance of the law is not a defense. Federal charges mean federal sentencing guidelines, which are dramatically harsher than most state charges. The BRUEN framework just got rewritten. 2 years ago, the Supreme Court decided New York State Rifle and Pistol Association versus BRUEN, and that case completely changed how gun laws are supposed to be judged. BRUEN said courts must look at text, history, and tradition, not modern policy interests. After BRUEN dropped, lower courts went absolutely wild with different interpretations. Some judges started demanding the government find a law from 1791 that matched the modern regulation almost word for word. Other judges allowed broad historical comparisons that basically let anything pass. Federal appeals courts were issuing contradictory rulings on similar laws. It was chaos. Rahimi just ended that chaos with one phrase: "The Second Amendment is not a law trapped in amber." Chief Justice Roberts wrote that you don't need a historical twin, you need a historical analog. That means the modern law doesn't have to match an old law perfectly. It has to be analogous in how it works and why it exists. The court specifically rejected the idea that the Constitution froze gun rights in the exact form they existed in 1791. This changes everything for pending gun cases across the country. Magazine capacity limits, assault weapon bans, permit requirements, sensitive place restrictions, every single one of these cases will now be argued using the analog framework instead of the twin framework. Governments will have an easier time defending some regulations. Gun rights groups will have better arguments against other regulations. The battlefield just shifted, and most people don't even realize it yet. Drop a comment below. Do you think historical analogues should decide modern gun laws? Or should courts use a different test entirely? How restraining orders became federal gun cases. Let me walk you through how a family court matter becomes a federal felony. Because this process is how thousands of people end up in prison without understanding what happened. It starts with 18 U.S.C. Section 922, subsection G, and paragraph 8, a federal law that makes it illegal to possess firearms while subject to certain restraining orders. This isn't a new law. It's been on the books since 1994. But most people have never heard of it until they're being prosecuted under it. The law requires three things. First, you received notice and had an opportunity for a hearing. Second, the order restrains you from harassing, stalking, or threatening an intimate partner or child. Third, the order either explicitly prohibits firearm possession or includes a finding that you represent a credible threat. If all three elements exist, possessing a gun becomes a federal crime punishable by up to 10 years in prison. Here's where it gets tricky. Many people think restraining orders are civil matters that don't affect criminal rights. Wrong. Federal prosecutors can and do charge people under Section 922, subsection G, paragraph 8, even when no criminal domestic violence charge exists. You could be a person who's never been arrested, never been convicted of anything, and suddenly you're facing a decade in federal prison. The Bureau of Alcohol, Tobacco, Firearms, and Explosives investigated over 5,000 cases involving prohibited persons in possession of firearms last year. The First Amendment angle nobody sees coming. Now let's talk about why the First Amendment is suddenly part of this conversation, because this connection is more important than most gun owners realize. The Supreme Court has another major case on its docket involving government officials pressuring private companies to censor speech. That case is Murphy versus Missouri, and it deals with whether the government violated the First Amendment by coordinating with social media platforms to suppress certain viewpoints. The core question is simple. Can government officials use informal pressure and threats to make private companies do what the government can't legally do itself? This matters to gun rights because the same pressure tactics have been used against the firearms industry for years. In 2018, New York's Department of Financial Services issued guidance urging banks and insurers to cut ties with gun businesses and advocacy groups. Multiple financial institutions responded by dropping lawful gun-related clients. The National Rifle Association sued, claiming this was an unconstitutional attempt to silence gun advocacy through economic coercion. Payment processors have terminated accounts for gun retailers. Banks have refused loans to firearms manufacturers. Insurance companies have declined coverage for gun ranges and training facilities. In each instance, the business was operating lawfully, but financial services companies decided gun-related commerce was too risky or too controversial. Free speech isn't just about talking, it's about associating, advocating, and conducting lawful business. If the government can pressure private companies to blacklist an entire industry, then the First Amendment becomes meaningless. Financial deplatforming and the speech war. Financial deplatforming has become one of the most effective tools for suppressing speech without officially censoring anyone. Here's how it works in practice. A gun advocacy group wants to run educational campaigns, so they need payment processing for donations and merchandise sales. Payment processors like PayPal, Stripe, and Square have terms of service that allow them to ban gun-related transactions. The group gets deplatformed. No law was broken, no regulation was violated. But the organization can't function without basic financial infrastructure. Banks operate under similar dynamics. Firearms businesses struggle to obtain merchant accounts, business loans, and even basic checking accounts. A 2019 survey by the National Shooting Sports Foundation found that 75% of firearms retailers had experienced discrimination from financial institutions. Some banks explicitly exclude firearms businesses in their terms. Others quietly decline applications without explanation. The government's role in this process is murky but significant. Operation Choke Point, a Department of Justice initiative from 2013 to 2017, explicitly targeted lawful businesses the government deemed high risk, including firearms dealers. Regulators send informal guidance. Politicians make public statements. Agencies launch investigations. Financial institutions respond by distancing themselves from controversial industries to avoid regulatory scrutiny. Nobody issues an official order. Nobody violates the First Amendment directly. But speech gets suppressed through coordinated pressure. What's your take? Should banks and payment processors be required to serve lawful gun businesses? Or should they have the right to refuse? Let me know in the comments. The 3 mistakes that cost gun owners everything. Let me tell you about the 3 most common mistakes that turn lawful gun owners into federal defendants. The first mistake is treating protective orders like relationship drama instead of legal landmines. When someone files a restraining order against you, your immediate reaction might be anger, denial, or dismissiveness. You think it's temporary, you think it'll blow over, but here's what actually happens. If you don't show up to the hearing, the order gets granted by default. If the order contains specific language about threats or credible danger, you've just triggered federal law. And if you keep your guns at home thinking it's no big deal, you've committed a federal felony. The second mistake is posting on social media during legal conflicts. You're angry, you're venting. You post something like, "She's going to regret this," or "I'm not going to let this slide." You think you're just blowing off steam. But prosecutors screenshot those posts and present them as evidence of threatening behavior. Courts interpret ambiguous statements against you in protective order hearings. What you meant as frustration gets read as intimidation. The third mistake is assuming civil proceedings don't affect criminal rights. Family court feels less serious than criminal court. There's no prosecutor, there's no jury, you might not even hire a lawyer. But federal gun laws don't care what kind of court issued the order. If it meets the statutory requirements, it triggers the gun ban. Civil and criminal law intersect in ways most people never anticipate. What historical analog really means for future cases. The historical analog standard from Rahimi is going to reshape every Second Amendment case for the next decade. Let me explain how this test actually works in practice. When a court evaluates a gun law now, it must ask 2 questions. First, why does this law exist? What's the regulatory purpose? Second, how does this law burden the right? What's the scope and severity of the restriction? If the modern law is analogous to historical regulations in both purpose and burden, it survives. If it's not analogous, it fails. This framework sounds simple, but it's actually incredibly complex because history is messy and contradictory. Colonial America had laws requiring gun ownership for militia service. It also had laws prohibiting certain people from carrying weapons in specific circumstances. Some colonies restricted concealed carry. In others regulated storage of gunpowder. There's no single historical tradition. There are multiple overlapping traditions that sometimes conflict. Here's where this gets interesting for future litigation. Magazine capacity limits will be argued using historical restrictions on ammunition storage and dangerous weapons. Assault weapon bans will be compared to historical regulations on unusual or dangerous arms. Permitless carry laws will be defended using historical presumptions of armed citizenship. Sensitive place restrictions will be justified through historical precedents about weapons in courthouses, polling places, and legislative assemblies. Every argument will be framed as an analogy, and both sides will claim history supports their position. The Supreme Court basically told lower courts, you're going to have to do actual historical analysis instead of just picking the outcome you prefer. How to protect yourself starting today. Let me give you the practical steps you need to take immediately if any of this applies to your situation. If you're currently involved in any kind of family law matter, restraining order process, or domestic dispute where legal action might be filed. You need to understand the firearm implications before you get blindsided. Read every court document carefully. Look for specific language about threats, danger, credible harm, or weapon restrictions. If any of that language appears in a proposed order, you need to understand that gun possession could become illegal. Don't assume your lawyer knows this. Many family law attorneys don't specialize in federal gun law. If you own firearms and someone threatens to file a protective order against you, do not send angry messages. Do not show up at their residence. Do not post anything on social media that could be construed as threatening. I'm not telling you to accept false accusations. I'm telling you that anything you say or do before the hearing can and will be used to justify the order. Courts err on the side of caution in protective order cases, which means ambiguous behavior gets interpreted against you. If you run any kind of gun-related business, organization, or advocacy group, you need to diversify your financial infrastructure. Don't rely on a single payment processor or a single bank. Have backup options. Document any denials of service, especially if they happen after government officials make public statements about your industry. If multiple financial services companies drop you simultaneously, consult with a First Amendment attorney about whether you have a claim for unconstitutional state action. What's the biggest misconception you had about this Supreme Court decision before watching this breakdown? Let me know below. The Supreme Court just rewrote how gun laws get judged, and most people completely missed it. This affects every gun owner in America, whether you realize it or not. If you want to stay ahead of these changes, hit that subscribe button right now. Don't learn about your rights the hard way in a courtroom. Stay informed, stay protected.